This is an evidence hypothetical that arises out of the criminal law, and this is a very interesting and useful question. You'll see questions very similar to these on the multi-state, and this is perhaps a classic essay question. We can see just by glancing at the fact pattern that there are 6 calls of the question, and just a very cursory glance indicates that they are evidence questions. So we can pause for a moment and acknowledge that our basic outline of this question is going to have 6 Roman numerals. And briefly, we will consider logical relevance for each of these 6, and then we will reach a conclusion with regard to admissibility based on the objections. Let's just take a quick glance through the 6 items of evidence. In item number 1, we've got the testimony of Don about other residents telling him something, clearly hearsay. In item number 2, we've got testimony of Fred asserting specific acts, evidence. It looks like a character question. In item number 3, we've got the testimony of Mindy, and this appears to be more complicated than the first 2, in that Mindy is actually saying 2 different things. First, that Don is nonviolent, and second, that he walked away. Well, the first of these looks to be opinion, the second appears to be specific acts. Next, we see the prosecution in play. Item number 4 is a certified judgment. This appears to be bringing up at least authentication issues. We'll consider it more carefully in a moment. Item number 5 we take a look at. It's the testimony of Smith, with a long acquaintance with both the victim and the defendant, Don, and we've got character evidence here with the defendant being said to lie to a census taker. That appears to be collateral to the issues at hand. And then in item number 6, we've got Smith's testimony about Vic and Don. These appears to be opinions that touch on character. Fair enough. That's a very quick glance. And do you see how you don't need to be a great scholar to make fairly quick assessments of what is at issue? Now, you do have to be skillful to write careful, well-organized, thorough answers to a question like this. And on the multi-state, as you'll see very early on in your practice, reading is what the real subject is. You're being tested on your ability to read primarily. And then the secondary issue is how well you know and can apply the laws of evidence. So let's go to the top of the question and carefully look at it and see how we might organize and craft a sensible answer. And let's make sure we know what the black letter law rules are as well that govern the answer. We look up at the top and we see that Don has been charged with murder. The prosecution claims that Don started a fight. He and Vic got into this fight, and the defendant stabbed the victim. Don is testifying in his own defense. He argues that the victim started the fight and that Don drew the weapon only when he became afraid that Vic was going to beat his brains out. So we see the defense is offering the first 3 items of evidence. The prosecution is raising the second 3 items of evidence. Turn the page and have a look at the outline of issues that I've presented. You'll see that this is really a very thorough recitation of what is at issue and what the answers are. You can see that actually writing an answer based on this outline would be a lot more like paralegal or secretary work. The lawyer's work is in organizing a response to this question. When we're dealing with this many items of evidence on a timed essay, organization is key. And the good news is evidence is the easiest subject on the bar exam to organize. You can organize all of them in fundamentally the same way. We think about logical relevance, we move into as many of the objections as are applicable, and then we reach a conclusion with regard to admissibility. So let's carefully examine each item of evidence from each of the 6 calls of the question, and let's apply the law to the facts that are presented to reach conclusions that make sense and that are supported by the law. We begin with item 1. This is Don's testimony. Testifying in his own defense during his murder trial, Don testified that several other residents of the boarding house told him that Vic was out to get him. This is relevant because it supports Don's self-defense justification for killing Vic. The only real objection that applies is hearsay. The warnings Don testified about were out-of-court statements. If Don is attempting to present this evidence as truth of the matter asserted, the hearsay rule will prevent admission of the testimony. But if Don is merely presenting this testimony to show his state of mind or its effect on the listener, it will be admissible as non-hearsay. Don is entitled to testify that he reasonably believed that Vic was out to get him because of what he heard from other residents. This use of the testimony would not attempt to show that the statements were true, only that Don reasonably believed them to be true. For that purpose, the testimony is probably admissible. So now we turn to Fred's testimony. Fred testified that he had seen Vic start many fights. This testimony is relevant because it supports Don's self-defense justification for killing Vic. The objection is character evidence. Although Vic's character is relevant to Don's self-defense claim, the potential problem with Fred's testimony is that it presents specific bad acts of Vic in an effort to show that Vic probably acted in accordance with them. As I'll mention in a minute, reputation evidence is admissible character evidence, but specific acts evidence generally is excluded. In a criminal case, however, the defendant is allowed to bring in character evidence about the alleged murder victim, including specific acts evidence. This right is subject to some limitations, especially with regard to past sexual conduct of an alleged rape victim. But the black-letter law conclusion, based on the federal rules of evidence, is that Fred's testimony probably comes in. Next, we turn to Mindy's testimony. Remember that Mindy had a couple of different things to say on the stand. First, she was saying that Don is nonviolent, and then she was saying that Don walked away from various confrontations. So let's start with her first testimony, that Don is nonviolent. Mindy is the manager of the boarding house in which Don and Vic both lived. Her testimony about her opinion is that, in her opinion, Don is ordinarily a nonviolent person. This supports the defense depiction of Don's personality. The objection that the prosecution would raise would be that it is improper opinion evidence. But lay witnesses are entitled to offer non-expert opinions, assuming a proper foundation is presented. As the boarding house manager, Mindy probably has had sufficient contact with Don to be entitled to an opinion about Don being nonviolent. So I would conclude that the first part of Mindy's testimony, that Don is nonviolent, should be admissible lay opinion. So now, let's take a look at the second part of her testimony, that Don walked away. Mindy testified that she remembers several occasions in which Don walked away from potentially explosive situations in the boarding house. This testimony is relevant for the same reason her opinion testimony is, because it supports the defense depiction of Don's personality. Again, the objection would be character evidence, and here, the problem with this part of Mindy's testimony is that it uses evidence of specific good acts to depict Don as having a nonviolent character. This evidence is inadmissible specific acts character evidence, which is distinguishable from Fred's testimony that I just discussed a moment ago with regard to the second item of evidence. So here, with regard to Mindy's testimony, I would conclude that the second part of her testimony is inadmissible specific acts evidence. So now, let's have a look at the certified judgment from item 4. This is relevant because it supports the prosecution and it rebuts claims by the defense. The prosecution is offering evidence of a certified judgment of an 8-year-old conviction of Don for assault with a deadly weapon. The evidence is relevant because it supports the prosecution's depiction of Don, and it rebuts the defense evidence that Don is nonviolent. There are several possible objections to this item of evidence. The first would be authentication. The facts are silent as to whether or not the prosecution has properly authenticated the document. It's possible that the certification of the judgment makes the document self-authenticating. Next, the defense would like to argue that the item is more prejudicial than probative. This prior conviction for assault has no probative value about Don's truthfulness. It is not evidence about Don's conduct during the incident that led to the death of Vic. Furthermore, it is highly prejudicial to Don because it rebuts Don and Mindy's testimony that Don is nonviolent. If Don's assault with a deadly weapon conviction was not a felony conviction, it's inadmissible. If it is a felony conviction, it isn't too old to be admitted because it happened 8 years ago. And the federal rules allow felony convictions as old as 10 years. Finally, the defense will argue that the certified judgment is improper character evidence for rebuttal. This is the most complicated and interesting of the defense objections. The problem with this evidence is, like the evidence that we covered in the second and the third items of evidence, it is specific acts evidence, being offered to show character. Another problem is that the prosecution never asked Don about the conviction before seeking to introduce extrinsic evidence of it. Since Don testified in his own defense, the prosecution's failure to question him about it could be considered a waiver of their right to present the certified judgment. And I would suggest that this is the best conclusion. I would conclude that the certified judgment should be excluded as improper character evidence for rebuttal, and also because it's probably more prejudicial than probative. Next, let's turn to Smith's testimony that Don lied. Smith testified that he heard Don tell several lies to a census taker. This is relevant to show that Don, who testified in his own defense, does not tell the truth. There are a couple of objections. The first would be hearsay. Smith is testifying about alleged out-of-court statements by Don. Assuming that Don testified that he has told the truth to the census taker, Smith's testimony would constitute a prior inconsistent statement, which would be an exception to hearsay. But the real problem with Smith's testimony is that it is improper character evidence for rebuttal. Smith's testimony is extrinsic evidence, and it's being used to impeach Don on a collateral matter. Whether or not Don lied to a census taker is not a material issue in his trial for the murder of Vic. Although the prosecutor did have legal grounds to ask Don about his interactions with the census taker during cross-examination, it is impermissible for the prosecutor to use extrinsic evidence to impeach Don. I conclude that this item of evidence is inadmissible because it is improper character evidence for rebuttal. So, finally, let's take a look at Smith's opinion evidence. Smith testified that in his opinion, Vic was not aggressive, but that Don has a very short fuse. This testimony by Smith is relevant because it supports the prosecution's depiction of Vic and defendant. The first objection would be that this is improper opinion evidence, but, as I've already discussed, a lay witness may give non-expert opinion testimony if a proper foundation has been presented. Smith is another boarding house resident with long acquaintance with both Vic and Don. This testimony is not improper opinion evidence, so let's consider it as character evidence. We see that here the defense has opened the door to the character issues in the case by claiming self-defense, by presenting the testimony of Don and Mindy, and by trying to present the testimony of Fred. The prosecution is entitled to present Smith's testimony in rebuttal. So I would conclude that Smith's testimony is relevant and that it is neither improper opinion evidence nor improper character evidence. My conclusion would be that Smith's opinion evidence should be admitted. And that wraps up a consideration of a very straightforward evidence problem, presenting very standard issues in very standard ways. If this question is novel for any reason, it's because it presents so many issues in a single essay question.